Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We have been providing you with updates regarding Judge Stephen J. Hippler's December 18th, 2025 court order directing that dozens of documents that were under seal and therefore outside of the public domain for the months of January, February, and March 2025 were to be unsealed and released to the public in the extraordinarily highly sealed case, in my opinion, of Idaho versus Kohberger. A week has come and gone since Judge Hippler signed that court order, as he did on Thursday, December 18th, 2025, and a review of both the court docket and the case summary page maintained by the clerk of court to document all key events in the case demonstrate that, number one, nothing has been released to the public as of yet, in compliance with Judge Hippler's December 18th, 2025 order. And number two, the case summary page maintained by the clerk of court has not been updated since December 18th, 2025. As court is now closed for the day and for the Christmas holiday, it is anticipated that nothing will be published tomorrow, December 25th, the first possible time that anything could be released to the public regarding these long sealed, incredibly important documents will not be released until Friday, December 26th, 2025, which is the next scheduled date when court will be reopened. At this time, I would like to read a quotation from a 1980 United States Supreme Court ruling indicating that the public has a fundamental First Amendment-based right to attend criminal trials to ensure fairness and transparency, even though this is not specifically stated in the U.S. Constitution. And this is from Richmond Newspapers Incorporated versus the Commonwealth of Virginia. Quote, in guaranteeing freedoms such as those of speech and press, the First Amendment can be read as protecting the right of everyone to attend trials, so as to give meaning to those explicit guarantees. The First Amendment right to receive information and ideas mean that the guarantees of speech and press, standing alone, prohibit government from summarily closing courtroom doors, which had long been open to the public at the time that the First Amendment was adopted. End of quote. And that is the United States Supreme Court's interpretation of the First Amendment, re-emphasizing that the public plays an important gatekeeping role to ensure that the government is not overstepping its bounds regarding the enormous powers judges, prosecutors, and even defense attorneys hold. It is the public whose role it is to ensure that this country does not operate like a sovereign who says what it is without any input from the people. The First Amendment to the United States Constitution, implemented in the Bill of Rights by the 13 original colonies who became the 13 original states, required. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedoms of speech or of the press or of the right of the people peaceably to assemble and to petition the government for redress of grievances. We will continue to keep you updated as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.